Hello and welcome to the Labour Campaign for Human Rights panel discussion with Professor Francesca Klug. Francesca is currently a visiting human rights professor at LSE and an academic expert at Doughty Street Chambers, and she also sits on the Labour Campaign for Human Rights Advisory Board. I'm Alannah, the Vice Chair, and Matthew is our Chair and Executive Director. We're really delighted to be joined by Francesca today. Francesca is a renowned human rights academic and one of the earliest campaigners and champions of the Human Rights Act, and she played an instrumental role in supporting the Labour government to establish the Human Rights Act in 1998, which essentially incorporated the 1950 European Convention on Human Rights into UK law for the first time. The Human Rights Act received royal assent in 1998 and it came into force in 2000, and I'll link some further resources from our website to Francesca's work and other academic experts at the bottom of this video. So the focus of our discussion today will be on the backgrounds of the Human Rights Act and in particular the social, political context in the earlier sort of second half of this century, the 80s and 90s, leading up to the Act. The organisations and the individuals who called for an act, especially those within the Labour Party movement, and also the reservations held by others within the Labour Party, for example, Tony Blair, and also ultimately how the Labour Party came to adopt the Human Rights Act and the form it took. So to start, Francesca has really been in the thick of human rights discourse over the past few decades, and she joined Liberty as director of the research arm of the Civil Liberties Trust in 1989, where she led the drafting of a Bill of Rights for public consideration, which was published in 1991, calling for a People's Charter. But of course, the campaign for a Human Rights Act, which to promote the cause of human rights, began far earlier than that, and 70 years ago, the European Convention on Human Rights was adopted. So please, Francesca, before we even get to Charter 88 and pressure under Thatcher's government and beyond, how did the campaign for human rights begin?
First of all, let me say, Alannah, it's absolutely delightful to be chatting with you and Matthew about this afternoon. And all credit to the Labour Campaign for Human Rights for all you do and keeping the issue of human rights firmly on the agenda. So let's go back in time now, bit of fun, bit of time travel. As you say, it's exactly 70 years ago that the European Convention on Human Rights was adopted, and this was under a Labour government, the great 1945 Labour government, but with a lot of support from Winston Churchill, as is well known. Until 1966, it didn't really have very much impact whatsoever in this country, just the odd case between states. But in 1966, the Wilson government introduced the right of petition. It was, for the very first time, possible for individuals here to take cases at the European Court of Human Rights when there were breaches of their human rights. But it took a very long time often for a case to get to Strasbourg, and it took a lot of money, and there was not a substantial case law, although there were some very fundamental changes that took place through that mechanism, not least the decriminalising of homosexuality, using the language of the day, in the whole of the UK. I think a big turning point that put the idea of either incorporating the European Convention on Human Rights into UK law on the agenda, or indeed a Bill of Rights. And I have to say, right from the beginning, the two terms were used pretty interchangeably. So the big shift, really, where it began to occur to people that a Bill of Rights of some form was necessary in this country. Remember that this is Britain, and it was always seen as the mother of democracy and the freest country in the world was the self-image. Again, happened under a Labour government, this big shift, but it wasn't such a happy story as the one I've told so far. It was the Commonwealth Immigrants Act of 1968, which brought the idea of a Bill of Rights into some degree of public consciousness. And this was a big dramatic time when racism was very entrenched in the discourse and the laws of this state. And it was at the height of powerlism, Enoch Powell making inflammatory speeches. And there was a lot of tension in the country. British Asians at the same moment were being expelled from newly independent states in East Africa. they had a British passport, and they felt they were safe because now they could use their British passport to come to the UK. But exactly when they needed the protection of their passport was when the British government, within 3 days, passed the 1968 Commonwealth Immigrants Act to prevent them from having an automatic right of entry to this country, unless they were born here or had a parent or grandparent who were. The racism implicit in that legislation was pretty obvious, and the discourse made it so. This was really a very thinly disguised example of institutional racial discrimination at a time of open and explicit racial tensions. A voucher scheme was introduced, which effectively turned British citizens into refugees. And this exposed the limits of majority rule. But it wasn't until 1981 that the expelled East African Asians were finally vindicated by the European Commission on Human Rights at Strasbourg, which declared that racism is a breach of Article 3 of the European Convention on Human Rights, which, as a form of inhuman and degrading treatment, a special form of affront to human dignity, the Commission said. This was a big moral win, but it didn't really do much to remedy the situation for East African Asian people who had a British passport. Really, what the European Convention did in this case is provide something that nearly 800 years of English common law liberties failed to do. It recognized the fundamental human rights of everyone, the most important word in the European Convention, regardless of how unpopular or marginalized they were by the majority in a democratic state. So whereas parliamentary sovereignty offered these UK citizens no protection at all, I should say UK subjects, which is what they technically were, the European Convention at least provided a moral redress with that description of racism as a breach of Article 3, one of the few unqualified rights in the European Convention that must never be breached. But it didn't restore their any effective citizenship to these British subjects, and they remained effectively stateless Brits. The campaign for a domestic Bill of Rights based on the European Convention on Human Rights began. The fire was lit. Then we go into the 70s. And of course, the 70s are famously known as the era of the Troubles, which was a euphemism, if ever there was one, for the civil strife in Northern Ireland. Running forward very fast, after the Guildford and Birmingham pub bombings in 1974, once again, the government of the day introduced the Prevention of Terrorism Act in now not 3 days, but 4 days. Although popular in some ways, under media-generated pressure to obtain convictions, large numbers of UK citizens, this time of Irish origin, were detained, effectively creating a suspect community, with some convictions turning out to be serious miscarriages of justice, as we all know, which is, of course, in the news right now, because as the recent arrest for the 1974 Birmingham pub bombings reminds us, the Birmingham Six languished in jail for 16 years with no recourse. This all added to the sense that vulnerable or unpopular, as it were, minorities could get no protection under a system based on majority rule, or as we call it, parliamentary sovereignty, where Parliament has the final word, but very often that means government has the final word, because under our system, there is no real separation between Parliament and government. MPs form the government, and all MPs in their parties are under the rule of the whip, which is sometimes very, very hard whip indeed. Lord Scarman in 1974, the famous Liberal judge, summed up the situation brilliantly in his renowned Hamlin lecture. What he said was this: when times are normal and fear not stalking the land, English law sturdily protects the freedom of the individual and respects human personality. But when times are abnormally alive with fear and prejudice, the common law is at a disadvantage. It cannot resist the will, however frightened and prejudiced it may be, of Parliament. And when in my lifetime, the Parliament and the popular will has been frightened and prejudiced on and off most of the time. So in the 1970s, there began to be some all-party support for the idea of a Bill of Rights. In 1976, for example, the Lord Chief Justice, Lord Hailsham, famously coined the term elective dictatorship to describe the UK system of parliamentary sovereignty that I've just described, at least when Labour were in power. In 1976, a Society of Conservative Lawyers published a pamphlet called Another Bill of Rights, and they argued, hold your breath in here, they argued that the European Convention on Human Rights should be given statutory force as overriding domestic law. In other words, that parliamentary sovereignty should apply except insofar as legislation complies with the European Convention on Human Rights. That was the Society of Conservative Lawyers. I say that for you who cannot believe that the tables could have turned that much in 40, 50 years. In those days, it was Labour who was far more sceptical of the idea of a Bill of Rights than many Conservatives. In 1979, hold your breath once again, the Tory manifesto under you-know-who, Margaret Thatcher, said that she would introduce discussions on a possible Bill of Rights. But this pledge disappeared without trace once she was in power, as I think you all know. In other words, elective dictatorships are not so bad when you're doing the dictating yourself. Shall I continue, or are there any questions you'd like to ask me at this point, Alannah?
No, that's really interesting. I'm very interested in the campaign groups that began to spring up in this period. So I think I alluded to your experience at Liberty in the introduction, but perhaps particularly Charter 88 seems to play a really crucial role in dragging these issues to the forefront under Thatcher. So perhaps you could share a little bit of your experience.
I will. I mean, before Charter 88, and whilst I was still either at university or on my gap year wandering around Africa as a young person with my kaftan and hitchhiking thumb, the House of Lords Select Committee in 1978 actually did hold an inquiry into whether to introduce a Bill of Rights. But it was the 3 Tory members and only 1 Labour who supported it. The Liberals, on the other hand, and that's what they were called then, were always in favour of a Bill of Rights and constitutional reform more generally. And those Labour MPs who left the Labour Party in the early 80s to form the SDP, they tended to be the ones who supported the idea of a Bill of Rights based on incorporating the European Convention, and particularly thinking here of Shirley Williams and Roy Jenkins, but also Anthony Lester, who had advised Roy Jenkins and was one of the early founding members of the SDP himself. He rather took over the mantle of Lord Scarman in leading the case, along with other Liberal lawyers, for a Bill of Rights. This takes us to the 80s and the formation of Charter 8 in 1988, which basically came out of 18 years of Tory rule, which really turned the tide on this issue. 3 elections were won on a minority of the popular vote by the Tories. As someone who has now got a strong memory of this, I can tell you that it felt like it would never end. The Conservative government demonstrated that it could enact virtually any measure it chose, with the courts entirely powerless to intervene. Growing elite awareness is how I would describe it, because I could not pretend there was a mass mobilized campaign for a Bill of Rights. But there was a growing elite awareness that in other European countries, or for that matter in the States, challenges could be mounted through the courts or even at the level of protest by citing their constitution or Bill of Rights, challenges that were simply not possible here. The response from Margaret Thatcher to any questions about a Bill of Rights dashed any lingering hopes that her manifesto commitment to discussing one was even remotely possible, or a faint memory from the Iron Lady. When asked about it, she wrote, "The government considers that our present constitutional arrangements continue to serve us well, and that the citizens in this country enjoy the greatest degree of liberty that is compatible with the rights of others and the vital interests of the state." I must admit, I did watch The Crown last night. I don't know if you did, but I don't think I've quite got her accent, but it's a little bit more present in my mind than it would have been. Were you going to say something there, Matthew?
Well, no, I wasn't, but a particularly interesting observation, though. You said it's sort of this awareness among the elite, but that was, I'm interested in the link between that thought process around a solution to the problem being right and what was happening on the ground in terms of the poverty that was being created in the 80s that led to protests and that was met with authoritarianism. I'm thinking the connection between that sort of ideology among what you described as the liberal academic elite and the struggles by miners or poll tax demonstrators on the ground, as it were.
And you're absolutely right to make the link. I mean, this was the period of the bonfire of the liberties, one thing after another. Some were very much in the minds of liberal lawyers, and civil libertarians in general. And I, by this time, at the very end of the 80s, joined Liberty and became director of their charitable trust, the Civil Liberties Trust, as Alannah said. And for us, you know, we were very focused on the fact that, for example, the right to silence, which had been well established in common law since the 17th century, was overturned, and that offences like common assault could no longer be tried by a jury. There was the famous Spycatcher book ban and the 1989 broadcasting ban of Sinn Féin and other Irish groups. But at the same time, there was also the incredibly heavy-handed policing of the miners' strike and the poll tax protesters. And I remember it coming up that in America, poll taxes were overturned by local federal courts. But this couldn't happen here. And in America, books couldn't be banned before they were published, but we could do nothing about it here. So gradually, constitutional issues started to attract interest beyond liberal lawyers, and went as far as the sort of NGO sector, if you like. And so when I say elite, I don't necessarily mean people with big checkbooks. I mean it was people who were engaged in these issues, from grassroots campaigners to barristers to certain select politicians. And Charter 88 captured that zeitgeist and also got artists, playwrights, opinion formers involved. And they mounted a very successful thought process campaign about examining, really for the first time, possibly since the Chartists in the early 19th century, a campaign and a sense of consciousness about what does it mean to live in a democracy? What is our democracy capable of doing and not doing? And what does it mean to have an unwritten constitution which is somehow impossible to pin down and yet is unviable? Sorry, and yet is, you know, you can never ever change it, and yet you can't get hold of it and say what it is either. You know, what are the implications of that? That became much more part of the everyday discourse than it had, I think, been for a very, very long time through the success of Charter 88. And this started to impact on the consciousness of the Labour Party without a doubt. Of course, at the same time as this, and Charter 88 was in itself influenced by what was going on in Eastern Europe. So you had the sort of build-up of the Velvet Revolutions, which was the, if you like, first human rights revolutions, even vaguely recognized as such since, if you like, the French Revolution. And then in 1989, the Berlin Wall came down. I mean, no one was marching, as I said, in the streets for a Bill of Rights, but as Helena Kennedy put it, there was a new zeitgeist around the idea of human rights, which sort of went alongside a broader campaign for constitutional reform and looking at the way our unwritten constitution works. And we know that the Labour government, you know, took on board a lot of this. And right now, this very week, Boris Johnson was challenging another aspect of it, which was devolution. These things at the time through Charter 8 were not being discussed independently of each other, but at the same time, the whole sense that human rights were crucially important in their own right was imprinted, I think, on the psyche via the events in the former Soviet Union and in Eastern Europe. So all this coincided. But there were still many, many skeptics within the Labour Party, and the three main objections were as follows. First of all, that parliamentary sovereignty would be eclipsed by the rule of judges. I mean, very much the same discourse as now. And, you know, looking over to the states, it was seen, yeah, they had advantages. They could challenge what we couldn't. But on the other hand, it was perceived to be ruled by unelected judges. And when you take that to Britain, this was the second issue, we're looking mainly at white male public school judges. And when I say mainly, I mean almost entirely when you're talking about the late 80s, early mid-90s. And there was a fear in particular among the left of the Labour Party that they would inevitably reduce the capacity of Labour to introduce a radical programme. And they had plenty of reasons for saying that. And the third kind of hesitancy, which probably went across all parties and really across all of us, was the fear of introducing a litigious culture. That issues that should be, you know, mediated and good people should be able to find a resolution for would no longer be attempted. You'd go straight to the courts, and the only people that would benefit were lawyers. Now, I mean, the discourse hasn't changed that much, to be honest. The debate has just kept going, but it's kept going in the face of actually quite considerable evidence to the opposite since the Human Rights Act has been in force, I would argue, but we'll come on to that. It is worth mentioning, and you'll be interested in this, Matthew, as a barrister yourself, that there was a series of sort of, you know, landmark cases, if you like, landmark cases that suggested the inadequacy of the common law, which is almost presented as a sort of symbol of Englishness and therefore as national pride. So therefore, you couldn't just have an ordinary debate, is the law effective or not? You always had to get through this layer of symbolism of the common law, which we saw as exporting, you know, to all around the world, including America, disregarding entirely that all the places we'd exported it to had now got bills of rights and written constitutions, almost every single one, and we hadn't. So these cases were important in terms of the sort of elite level of the debate to point out where common law was not effective. And the first really big case actually was in 1979, the case of Malone, which really highlighted the totally unregulated nature in this country of phone tapping and security services in general, and the argument in the case and why the law was unable to provide us with any protection was because as our law was silent about phone tapping, etc., therefore it was legal. Because where the law was silent, it was allowed. That was the principle of the common law. And, you know, people of my generation weren't satisfied with that explanation. All the spy cops that's coming out now, we all knew we were being spied on in our various NGOs. And we weren't at all happy with the argument that if the law shuts up, it's okay. The European Court of Human Rights, of course, declared that the total absence of regulation of state surveillance was a breach of Article 8, the right to a private life, under the European Convention on Human Rights, and the Interception of Communications Act was introduced in 1985, regulating mail and phone interceptions for the very first time in our history. Again, we were looking to the European Convention for any protection at all. It was simply unavailable in our courts. It's so important to understand this, because as we face an era where the Human Rights Act may be repealed and the common law is once again being extolled as the source of all wisdom and protections, we need to understand, because memory doesn't last very long, what it was like to live in this country with none of these legal protections. And I remember this very well. So in 1990, there was another very famous case which exposed the vacuum in the law, and it became very famous because wonderfully it involved someone from popular culture. This was just the sort of case we needed, and it came along at the right time, and that was concerning Gordon Kay, who's sadly I think died since then. He was the star of Allo Allo, which was very popular at the time, and he was recovering in hospital after a nasty accident, and suddenly he found himself being photographed by the now defunct Sunday Sport. And he naturally thought, this can't be right. And he went to, the British courts and sought the protection of the common law, as he'd been brought up to believe he could, in such a flagrant abuse of his privacy, only to be told there was no such thing in the common law as privacy. And again, if the law is silent, the photographer had the absolute right to walk into his hospital bed when he's recovering from a terrible accident and photograph him. This was a complete shock to him. It was a shock to all his fans. And Lord Bingham, who heard the case, lamented that yet again the failure of both the common law of England and statute to protect in an effective way the personal privacy of individual citizens. And it's important to bear in mind that word statute, because that takes us back to the Commonwealth Immigrants Act. The idea was, okay, when the common law is silent, statute can protect us instead. But that often didn't happen in real life to real human beings. And the final clincher was 1996, the case of Smith, which exposed the weakness of judicial review. Now, judicial review was coming up the track at this point because the courts themselves recognized that there was real vacuums in the protections of our law. And so they took things into their own hands, and they developed this principle of judicial review, which is not controlled by any kind of legislation, where the government, they couldn't, judicial review was barred from reviewing primary legislation, acts of parliament, but where decisions and policies were made, which were either unlawful or irrational, they could overturn them. When I say they could overturn them, this was a decision of the courts to argue that within the common law, they had the power to do so. One example of regulation was a blanket ban on LGBTQ men and women serving in the armed forces. Now, a judicial review to overturn this ban was long overdue by the time it was heard in 1996, but to everyone's shock, the Lord Bingham, who was a well-known believer in fundamental rights, who heard the case, was unable to do other but say that these regulations were not illegal and they were not irrational. Therefore, they had to stand. He himself lamented that he couldn't look at whether they breached the fundamental human rights of the armed forces personnel, because he wasn't allowed to do so. That is how life was before the Human Rights Act. And again, it took the European Court of Human Rights to overturn the ban and subtly damn the British constitutional system in the process for effectively excluding any consideration of the human rights of the sacked personnel. So while this was all going on, meanwhile, and this comes back to your point, Alannah, some of us were busying away at drafting our own Bills of Rights. You could even call it the Battle of the Bills of Rights at this point, because you had at IPPR, the Institute of Public Policy Research, a fantastic commission under Sarah Spencer, who was the main official at the IPPR who oversaw this project, and you had Lord Leicester again chairing it, a commission to look at a Bill of Rights for the UK. And the model they came up with, was independent, but mirrored the, if you like, the one that we know so well from America, where the courts could strike down statutes that breached the European Convention on Human Rights and other fundamental human rights. Whereas us over at Liberty tried to address this skepticism within the Labour Party, the Liberty being all party, but nevertheless having roots in the Labour movement. We tried to address the skepticism and the concern that a radical Labour programme would be overturned by white public school educated judges by looking to see if we could come up with what we called a democratic Bill of Rights. Actually, we proposed something so convoluted and so unimplementable that our model was never going to be accepted. But we implanted the idea that there was an alternative way to approach this issue. And Neil Kinnock took some interest in it. And if you look at the manifesto of the 1992 general election, Kinnock's election, where he sadly failed to win, you'll see that the manifesto does refer to a democratically enforced Bill of Rights. But after Kinnock lost that election and John Smith took over, there was another gear in Labour's interest in constitutional reform in general and a Bill of Rights in particular. And this is because John Smith himself was a Scottish lawyer with a long interest in constitutional reform, including devolution and including a Bill of Rights. In a speech to Charter 88 still making the weather, as you can see, he committed to supporting a Human Rights Act based, as was generally the case, on the European Convention on Human Rights, but he saw that as part of creating a citizens' democracy, as he called it. He had a vision for overriding constitutional reform. He had a sense that citizens in our country, and indeed all individuals that live here, are too disempowered to match up to the hopes and dreams of what a democratic society should look like. But his untimely and sudden death then led to Tony Blair taking over, and he was frank that he was initially sceptical about whether Labour should support a Bill of Rights, and he had written about his scepticism in the past. I was dispatched, I should say, still as director of the Civil Liberties Trust, or I may have just been moving on. No, I think I was still director of Civil Liberties Trust at this point, to meet Tony Blair and talk to him and persuade him that this scepticism was unnecessary because we were working on a democratically entrenched Bill of Rights, which would allow Parliament still to have the final say. And he then subsequently came out, I'm not saying that was the clincher, but he subsequently came out standing by John Smith's support for a Human Rights Act based on the rights of the European Convention and other aspects of John Smith's constitutional reform. You can debate why. A skeptic might say this was because whilst they were getting rid of so many other radical policies, they thought they'd better hold on to some, and the constitutional reform measures to them appeared to be not too threatening. Or you can say that this was a reflection of the mood of the time that they were very clever at tapping into. But either way, the Labour Party then committed themselves to a Bill of Rights of some kind or another, the term still being used interchangeably, Bill of Rights, incorporation of the European Convention. But whether they would have done that without this fantastic collaboration, and you asked me earlier, Alannah, about the role of pressure groups, this fantastic collaboration, I have to say, and that's what it was, between a whole range of us, academics and NGOs, including Liberty, IPPR, both of which I've already mentioned, Charter 88, but also Justice, the Public Law Project, the Constitution Unit at UCL, and particularly concerned lawyers like Anthony Lester still and other lawyers up and coming, whether it would have happened without that collaboration. I'm not saying we always agreed on everything, we didn't. Even within Liberty, working with John Wadham, Madeleine Colvin, Andrew Pudifat and myself, we had some great debates about what model to support when we were discussing in supporting a Bill of Rights based on the European Convention on Human Rights. But we did all ultimately decide to put away our disagreements and work together. Should I come on and tell you about the model itself? Is this the right time?
I think that would be really helpful. Sorry, Matthew.
Well, yeah, I wanted to ask some questions before we move on to that, if that's all right. But...
And also just couch it maybe for our viewers in sort of Labour Party politics as well, because obviously, I don't know, I feel like it's important to mention, and I know you alluded to it there, that Tony Blair was a little bit less gung-ho about the Human Rights Act, and how it was sold to the public is really interesting. And I think there are some interesting themes we could talk about, because as you said, it was obviously the commitment remained, but it was kind of sold to the public as a sensible step, bringing rights home, simply just, because we were already, the members of the ECHR anyway. So the fact was that it was just a natural step forward, and maybe your thoughts on that as well, I think would be interesting. But perhaps we could, come on to that. Sorry, Matthew.
And Matthew, did you also want me to cover something that
I've got a few questions that have come out of that. It's so interesting. The first is just about the wider constitutional reforms being called for by Charter 88. It was interesting looking at this. Some of the demands are proportional representation, freedom of information, reforming the House of Lords, etc. And a Bill of Rights was part of that. Was there discussion at that time of economic, social and cultural rights? is the first question, as part of that package of constitutional reform. The second is about the particular objection to a Bill of Rights with strike down powers by the left within the Labour Party. Now, I'm just curious, is the concern there, or was the concern there, that if, for example, property rights were interpreted as human rights, they would be used to stop redistributive policies, wealth redistributive policies by a radical Labour government? That's the second question. And then the third question, which links to what Alannah is saying about the internal discussions within the Labour Party. When you were dispatched to chat with Tony Blair and try to persuade him, what was Gordon Brown's involvement and role at that point? Was he in these discussions with you, and what was his view? Those are my three questions at the moment.
So they're great questions. What I'm going to do is try and keep to the chronology so that people watching this have a sense of time moving and context, but try and make sure I pick up all the questions you've asked me. And if I leave any of them out, by the time we've got to the end of this, remind me, and I will.
That sounds good.
Is that okay?
Yeah. Keep the momentum. Yeah.
So I mean, let's start with Gordon Brown, because that's quite straightforward. He wasn't really involved in the discussions as far as I recall at that point. He became involved much later, and I can try and come back to that at the end. But who was, of course, involved was Jack Straw, who was, so Tony Blair was Shadow Home Secretary. This is what we have to remember. He was Shadow Home Secretary to, when John Smith was leader, and Tony was therefore given the brief initially, which was actually, when I went to see him, he was still Shadow Home Secretary. That's when he acknowledged to me that he didn't really believe in Bills of Rights, but he could see the argument. And I do remember us having a very long debate about it in his office. Then when John Smith died and Tony Blair became leader, Jack Straw became Shadow Home Secretary. And the issue was, would they keep this commitment? I worked closely with Jack Straw from more or less then on, but Tony Blair, let's be honest, also married to Cherie Blair, who was a human rights lawyer, didn't ever resile from the commitment to introduce some kind of Bill of Rights based on the European Convention on Human Rights. We weren't actually using the phrase Human Rights Act very much at all at this point, although John Smith had done initially. We were mostly using the phrase Bill of Rights based on the European Convention. There was always a campaign to have, a second stage Bill of Rights, if you like, which would introduce economic, social and cultural rights. Now, when we drafted Liberties of People's Charter, that's going back to 89, came out, 90, and came out 91, I think. We had not included economic, social and cultural rights in it because it wasn't in Liberties as an NGO. It wasn't within their terms of reference. It was beyond what Liberty stood for, so we didn't have a remit to do that. However, what we did is we took the European Convention, and the general agreement was this. The reason why the European Convention was the baseline was what Alannah was implying earlier, that we were already signed up to it. So either because that felt safer for those with a more conservative bent, or because it felt like, well, that was an easier argument to win, because you were just saying, well, we're already signed up to that, so how can you object to that? From a more radical perspective, that was the reason for using the convention. There was a merging of those two positions. But many of us, in different contexts and guises, also argued we can add to it. So in the People's Charter, we added things like jury trial, we added things like children's rights, specific children's rights, disability rights, specific mention of LGBTQ rights. So that's how we approached it. But there was also a nascent campaign to add economic, social and cultural rights. And I sat on a group looking at that chaired by Graham Allen, who was an MP at the time, and he was in Tony Blair's shadow Home Office team with Jack Straw, and he was running a separate sort of discussion about economic, social and cultural rights. And the way that the politics worked out is that Tony Blair and Jack Straw were willing to commit to a Bill of Rights based on the European Convention, and they were coming from the angle, it's already agreed, we don't have to have a big debate about it, it feels safe, right? But they let Graham Allen, consult a bit with NGOs and others on expanding down the economic and social cultural rights route. But you'll find some reference, I think, in one of the manifestos to a second stage Bill of Rights. It was always left very vague. If you're asking me now, in hindsight, and even at the time, did I think this? I did. They never really intended to go further than the first stage. But, they were quite happy for people to go on debating a second stage. What Jack Straw, the gauntlet he laid down to those of us involved, was that we needed to do two things before they would absolutely commit to a manifesto commitment on a Bill of Rights based on the Convention. And the first one was to demonstrate that it was necessary. And that relates back to what we were saying about the common law. And I was involved in work to prove it was necessary, in particular at Essex University under Professor Kevin Boyle, something called the democratic audit. I was employed to audit our laws to see how much impact human rights, universal human rights thinking had on our laws, or whether the common law was adequate. And I did this review of all cases in the higher courts since 1953, when the European Convention on Human Rights actually was ratified into our law, and found only 172 cases where domestic judges had cited the European Convention at all in all those decades, and hardly any of them had it made a difference to the outcome. So in other words, we were signed up to the European Convention on Human Rights. We were signed up to many other treaties as well, human rights treaties, and they played almost no impact in people's actual real lives in the UK. They did have to do, as we had said in the propaganda, which is to wait sometimes 9 years, sometimes till they were dead, for their case to be heard at Strasbourg. There was a whole dead case law, literally dead case law, in that the people concerned were already passed on. That's how slow it was, and it was very expensive unless kind lawyers were prepared to act pro bono for anyone ever to take a case. So it was if we were serious about believing in the international human rights framework that we had promoted around the world and that had descended on our world after the Second World War through the Universal Declaration of Human Rights, which is really what the European Convention is, by the way. It takes the Universal Declaration, excludes the economic, social and cultural rights, ring a bell, and modifies some of the civil and political rights, but it's fundamentally drawn from the Universal Declaration of Human Rights. New way of thinking about democracies where every individual counts, not just majorities. Humanity trumps nationality when the chips are down. That is the thinking behind universal human rights law. So we managed at Essex, I think, to at least make the case with others that our current law was inadequate if we really meant what we were saying about human rights. Remember, post-89, this is the zeitgeist of human rights. This is the era when saying you were a human rights lawyer didn't mean you were necessarily insulted from the podium as lefty human rights lawyers with their grand theories of human rights. It was actually something people wore with a badge of pride. Universities started to teach human rights. This was all brand new. And when I went to Essex after I left Liberty and was employed there as a research fellow working for Professor Kevin Boyle, they were the first ever human rights centre with one of the first ever human rights LLMs and human rights multidisciplinary courses. It was all brand new. The Human Rights Act and the years building up to it introduced a whole new zeitgeist and way of thinking about our law and about the value of human rights. So we produced a book, The Democratic Audit, called 3 Pillars of Liberty, and I had a co-writer. Well, there was Stuart Weir who edited it, but I also had a co-author. The name may be familiar. It's Keir Starmer. I know where I've heard that name before. But we wrote the book together, which was launched and taken seriously by the Labour Party, making the case that Jack Straw said was necessary. But there was another big obstacle.
Francesca, sorry, can I just ask on that, on the democratic audit? Did it also look at cases at the European Court of Human Rights where the UK had been found to have breached the convention?
Well, it sort of followed on from showing the absence of protections here to look at the difference that the convention made.
Yeah.
But it wasn't primarily a study of the European Court of Human Rights. It was a study of our own courts and our own laws.
Yeah,
and I mean, Keir did some fantastic work on the inadequacies of our legislation, matching when you compare them to what was expected. We produced an index, what was expected by the European Convention on Human Rights. What's so interesting looking back is that was not a particularly contentious thing to do, because human rights law was not seen as contentious in and of itself. So that's why the wider international mood is very important to understand how this became possible. This was not the era of populist nationalism. This was the era of expansive universalism and shared ethos between democracies. It was a very good time to be relatively young and working in this field. And you know, obviously, as far as I was concerned, as someone who'd always been involved in anti-racism and looking at liberation politics from a young age, this was the place to be, to work on this optimism that came out of the human rights zeitgeist, was a way of opening up spaces that had been closed. You know, at different eras, open up different spaces. And this was where space was opening up. So the other gauntlet that was laid down for us very explicitly by Jack Straw is there weren't going to be a Bill of Rights unless we could solve this problem of parliamentary sovereignty, because they weren't going to overturn it. And so that meant some serious detailed work about coming up with a model that would respect parliamentary sovereignty ultimately. And I was incredibly lucky to be employed at King's College under Professor Robin Blackburn to do nothing but work on models for incorporating the European Convention on Human Rights. And that allowed me to look at bills of rights around the world, not just America, not just English-speaking countries, but Denmark, Germany, etc. And we came up then with a model. There were lots of brains involved, people that chipped into this work. The constitution units and well-known people in the legal profession that may not want me to mention their names. They've gotten to such illustrious heights now. But I was employed on a project called the Human Rights Incorporation Project. So it was my entire job. And the model that we came up with, working with many others, was more or less what was adopted after quite a lot of lobbying, and the lobbying involved the continuing collaboration between all the NGOs I mentioned before. This is what Labour basically adopted, and I do remember Jack Straw showing me the bill just before it was introduced into Parliament, and I do remember my eyes going on stalks. I was so amazed to see that what we'd all worked on for all those years coming into pass. There were some differences, but mainly it was there. And so you'd like me to describe this model, I think, in as simple terms as I can. So, okay, I'll have a go. So the courts, first of all, section 3, don't worry, anyone who's watching this thinks this is the time to switch off or go to sleep. Just bear with me, because it's going to be more fun than it sounds, I hope. So under section 3, the courts were required to interpret legislation, all legislation, including legislation already being passed. This was terribly important because there had been a move just to say it's going to work prospectively and not retrospectively. And we persuaded them that it would be toothless. Well, there's no point. You're going to raise all these expectations, and so it had to work going back, looking backwards and going forwards, and they agreed to that. So the courts would try now to interpret all legislation compatibly with the rights in the European Convention on Human Rights. But the big get-out clause was so far as it is possible to do so. I mean, let's just pause to think about it for a minute. We signed the European Convention on Human Rights. We ratified the European Convention on Human Rights. We tell everybody that this was Churchill's, you know, baby, and that we are the font of these human rights that we expect every other country in the world in one form or another, and certainly across Europe. And we just had this whole thing with the Eastern Europe and Margaret Thatcher being, you know, the front of this, you know, end of the Iron Curtain, and these ideas from, you know, the Helsinki Agreement. It's all part of the change. The Velvet Revolutions was they were going to adopt the rights in the European Convention on Human Rights. And yet it was completely missing from the consideration of our courts. And they did not feel that they needed to interpret legislation, or even could, even if they wanted to, like Lord Bingham. They couldn't even decide judicial review on the basis of human rights. That is how far removed we were from this thinking, right? And now, for the first time, the courts were being mandated to try to interpret legislation compatibly with the European Convention on Human Rights, with the rights in the European Convention on Human Rights. By the way, it wasn't all the rights, and there were a couple of rights that were elaborated on. So it's not literally the incorporation of the convention. A couple were missed out, a couple were elaborated on: free expression and freedom of conscience. But the idea that this is some radical thing to do, given we have the convention all those years, is quite extraordinary. But when could they not do so? They could not do so if it meant effectively overturning legislation, primary acts of Parliament, statutes, whatever language you want to use. This is because Parliament was still going to have the final say. So when it meant that actually you're going to turn a statute on its head, or give it a meaning that it couldn't possibly bear, right, then the courts would be prohibited for interpreting whatever the act said to comply with the European Convention. In that circumstances, they were then mandated to declare that the legislation in question was not compatible with the Human Rights Act, with the European Convention, with the rights in the Convention. So they could make a declaration of incompatibility, but they couldn't overturn the legislation in question, the Act of Parliament in question. And then it was up to Parliament, which in practice means whichever government's in power, what they did and whether they did anything at all. They've never been mandated, never, to repeal legislation, to change legislation because of a ruling under the Human Rights Act. Every time you hear a government member, no matter what party, saying, what can I do? The courts have told me I have to change the law on the, sorry, this is when I want us to switch off because I've forgotten what it's called. What do you get put on for life if you've committed a sex offence? Sex offence register, that's what it's called. Yeah. Sex offence register. You know, this is what Dave McCammon said. I don't want to allow anyone to ever have an appeal, and even if they were put on the sex offence register 13, I want them to stay on it for life with no appeal. What can I do? The courts have mandated that I have to change it. Not true. The courts issued a declaration of incompatibility. You didn't have to change it at all. That was a political decision. In my view, we made the right decision, but that's not the point. So this is political game playing. This is a Bill of Rights which retains parliamentary sovereignty. The other things worth mentioning about the model is that the purpose was not to make our culture litigious. The purpose was to introduce human rights into the warp and weft of our thinking. So the executive, legislative, and judiciary would all have a role in protecting human rights. So this was why the all-party Joint Committee on Human Rights was set up, so that Parliament would be versed in human rights and could have debates about human rights, because they were the ones going to have the final say. Ministers would be required under Section 19, whenever they introduce an act, to say whether it complies with the European Convention on Human Rights or not. They do that, but we couldn't persuade the government to require them to give reasons when they did that. We wanted them to, we couldn't persuade them to, and that means it's become a bit of a ritual that they say this bill complies with the Human Rights Act, whether it does or it doesn't. But nevertheless, it does put human rights on the agenda, and perhaps, you know, most importantly, it became unlawful for the first time for all public authorities to act in a way which is incompatible with the Human Rights Act, with the rights in the European Convention. And the idea of this was to introduce a culture shift. Now, in the way that our public authorities think, and we can come on and discuss whether that's happened or not, there were other things like non-primary legislation, rules, immigration rules, regulations could be struck down now, could actually be overturned by the courts as a breach of the Human Rights Act. But that didn't tie the hands of government either, because they could bring them back in primary legislation, which gets proper consideration by the whole of Parliament, which of course rules and regulations never do. This brings me to Alannah's point about the narrative, because this was a big change, but the government didn't know if they wanted to present it. Labour government didn't know if they wanted to present it as such or not. Sometimes, in fact, most commonly, they presented the change as minimalist. They produced this discussion paper, which wasn't discussed very much, called Bringing Rights Home. And the whole argument was, we already have these rights, and now all we're doing is nationalising them effectively, where we're actually increasing the sovereignty of our courts, because we're saying our courts can now determine them, not just the Strasbourg courts. And that is unarguably true. The narrative wasn't incorrect. It's just that that wasn't all it was. And so sometimes when they felt very expansive, particularly if they were talking to an audience for which this policy of a Bill of Rights using the European Convention was popular, they would use much more maximalist claims like, this is the most significant statement of human rights in domestic law since the 1689 Bill of Rights. I think it was Jack Straw that said that, and the Lord Chancellor Derry Irvine, who was also very important in this and a supporter of the Human Rights Act, but only on the basis that parliamentary sovereignty was retained. He would say things like, this is a major step change in the creation of a culture of rights in our country. And someone else said from the government, in future years, historians may regard the bill as one of the most important measures of this parliament. So there was a maximalist and a minimalist interpretation of what was being done, and no attempt to bridge these different impressions. This isn't really the way to prepare the public, is it, for major constitutional change? In fact, ideally, the public should be brought in from the beginning and should be consulted. But of course, they didn't want that. And that was one of the attractions of basing the whole Bill of Rights on the European Convention. They didn't have to consult because we were already signed up to it. Either way, minimalist or maximalist, really almost nothing was done to prepare the British people for such a potentially significant change. Only the judiciary was trained in the 2 years, and it was 2 years between the act being passed and coming into force. There were plans originally to inform every household with a pamphlet that was going to plop on people's doormats, explaining the purposes and benefits of the Human Rights Act, that it wasn't just meant to be for the courts, that it was meant to empower every citizen to challenge public authorities when they rode roughshod over their rights. But that was scrapped. So was the big launch that was going to happen. Instead, there was a much smaller launch in Church House, which was combined, it was very nice, with a competition for school students to say why this all mattered. What does human rights mean to you? But it was all a way of trying to hope that they could introduce this big change, but no one would really notice, and it wouldn't really make much difference. The only real consultation that ever took place, in fact, was run by Liberty, and under Andrew Pudifat, when he was General Secretary, he organised a 3-day convention on the proposals for a UK Bill of Rights, and it was attended by over 3,000 people and NGOs from Age Concern, Stonewall, a range of race, refugee, mental health, disability and gender equality groups, all attended, all contributed their responses and their thinking, but in the end, 3,000 people in a population of 60 million isn't very many, is it? So this was introduced without engaging the British people in this change. And I think it has taken 20 years for many people to understand what the Human Rights Act means. But I think perhaps we can come on discussing a little bit the impact. I think there is a growing awareness now, and I'll suggest to you why. But you may, have I covered all your questions?
That was brilliant, actually. Thank you, because I particularly think I'm not a lawyer and I'm not an academic expert in human rights, but just as a interested person in politics and how narratives are set, I think it's really interesting to reflect on how the Human Rights Act was sort of sold at the time, because I wonder whether that has really had an impact on the way people consider it today, and the culture wars around the Human Rights Act and tying it explicitly well, implicitly to the European Union. I know they're not connected at all, but you know, the average person might not particularly realise that. And yeah, I personally think that it was a massive shame that the Human Rights Act wasn't sold more positively at the time, and it was sort of slipped through. And I wonder whether Matthew has any thoughts on that too, but whether now the political tide has shifted so much that actually is the best that we can currently hope for, even though obviously the Human Rights Act has had a tremendous impact in the UK, and I think you can look at legal cases and, you know, it's pretty evident, but it's still getting such a lot of criticism and pushback. It's a really delicate situation. Yeah.
One connected point / question for you, Francesca. Was there some sort of, well, there was, I gather, a debate and a discussion about when you were creating the model as to whether these rights should be universal human rights or British human rights for British citizens, and that seems prescient at the moment, but maybe you could add a couple of words quickly about that discussion. And also there's my question about the concern on the left about a strike down mechanism, and whether it's about property rights or more than that.
So, I mean, yes, sorry, I forgot to address that. So taking that first, the concerns on the left really were that not trusting the judges to not use this to basically, at best, retain the status quo, and at worst to undo say more radical trade union laws if they were ever introduced in response to, you know, the curtailment of trade union rights under Margaret Thatcher. They feared that any chance that a Labour government would move things forward would in fact it would be counterproductive to have a Bill of Rights based on a lot on what's happened in America, where, you know, the philosophy of individual freedom and indeed property rights as being one of those individual freedoms would mean, even, for example, limits on election expenditure were overturned by the Supreme Court. So, you know, even sort of very minor curtailments of, you know, the right to spend your money on anything you want and to gain whatever power you could via those means were not looked on favourably by the Supreme Court in America. They were very worried that would apply here. I think those concerns, the concerns specifically about the property rights because of Protocol 1, I think they've been tempered over the years because, in fact, Protocol 1, which talks about a right to property, has mostly been interpreted as, you know, providing protections for people on benefits. For example, you know, both, I think, the widow persons, you know, the legislation which is the ruling, I should say, which has now allowed widowed parents to obtain a benefit which was not allowed to them if they were not married. It hasn't actually been implemented yet, but this was the ruling. The poll tax ruling, which said that, sorry, not poll tax, bedroom tax ruling, which said that certainly if you needed a spare room, say if you were disabled in particular, and you needed a spare room, you know, that this was a breach of Protocol 1, I believe.
That's a great example.
You know, the way that Protocol 1 on property has been interpreted by and large has been to protect the most vulnerable. So I don't hear that concern anymore, but there was that concern before the Act was introduced, theoretically. Indeed, there was that concern when the European Convention was ratified back in the 1950s by the Labour government then, that's what Protocol 1, the right to property, would do. Of course, that right was actually a reflection of what had gone on under Nazi Germany and other autocratic tyrannical regimes, where people's belongings were stripped of them overnight. And so it was really a misunderstanding of the spirit of the European Convention, which, as I say, came out of the Universal Declaration, which was drafted to protect the most vulnerable of the most vulnerable. It was not done in the idiom of the 1789 American Bill of Rights, which was about, yes, protecting liberty against the tyranny of George III, but it was also about protecting slave owners and people's property, private property. And it was about protecting the right to bear arms. This was a completely different philosophy. And it wasn't one that was tremendously familiar by some of the left critics of universal human rights. The issue about universalism was never, New Labour never ever considered reducing the universalism of the European Convention when discussing a Bill of Rights based on it. Not once do I recall that being said. It is true that subsequently, when they found that actually this measure did have teeth, that we had basically fulfilled Jack Straw's mandate to show that it was necessary and yet leave the last word with Parliament, meant that a measure had been introduced that could make a difference because there was a genuine lacuna in the law and because Parliament was uncomfortable to overturn a ruling such as the famous Belmarsh ruling introduced, which said that the indefinite detention of foreign people who were not British, didn't have British citizenship, and were suspected of terrorism, but it couldn't be proved, that their indefinite detention, unless they were prepared to be deported to a country where they either would be tortured or executed, probably extrajudicially, so unless they were prepared to be deported, they would be detained indefinitely without trial. When our court said that was a breach of the new Human Rights Act, the Labour government, New Labour, didn't like that at all and realised that the Human Rights Act was going to be an impediment. This was, of course, following 9/11, which you have to remember happened less than a year into the Human Rights Act's life once it was in force, and turned the tide on that zeitgeist of human rights. Then they wished to use it in ways that did discriminate between British nationals and non, and indeed that is why the ruling occurred, because the ruling was that the legislation was disproportionate in its discrimination, because it didn't apply to British nationals, and yet British nationals were just as likely to be terror suspects, as was proven to be with 7/7, just shortly after that ruling, not long after that ruling, and I think a year or two later. So it was it was genuinely discriminatory for no good reason, and that is human rights thinking. So if a measure is disproportionate, if it's not necessary, it doesn't serve a social good that is necessary, then it's disproportionate. And it doesn't matter if you're British or not. It's not your nationality or not that counts. It's the harm you can do. So then New Labour became discomforted by the lack of distinction, if you like. But the lack of distinction would not have protected us against terrorism, because the terrorism still took place by British nationals. And that is the kind of realisation that the Human Rights Act helped people think through. So Labour then turned on its own act, unfortunately. It didn't call to repeal it, but it did call to amend it, and briefed against it very frequently, and began the swell of drum beat of anti-Human Rights Act rhetoric in the media. Although I should tell you that if you look at what the Daily Express said the day that the European Convention on Human Rights was ratified in 1953, it's indistinguishable from anything it's said in the last few years about the Human Rights Act. So there was already, of course, a whole swell, in the tabloids of a certain bent, which was in principle against the idea of universal human rights. And this applied whether we have the Human Rights Act or not. But New Labour unfortunately fed some of that discourse as it became disenchanted with the initial impact of the Human Rights Act. Jack Straw went so far as to call it, at least to say, this is how it's become known as a villain's charter, and began the road of disenchantment, which was then picked up in the second phase by David Cameron. When he became Prime Minister, was the first manifesto to actually call for the repeal of the Human Rights Act. And in fact, every Tory manifesto since has called for the repeal, up to now with Johnson's manifesto in the 2019 election, which has had a slightly different rhetoric, which is about updating the Human Rights Act, these are the precise words, to ensure there is a proper balance between the rights of individuals and our vital national security and effective government. Now, you make of it what you will, But what is very interesting about that language is it's no longer calling for replacing the Human Rights Act with a British Bill of Rights, which is what the Cameron rhetoric was. Now, some people were quite seduced by this phrase, British Bill of Rights. They thought, I know, maybe we should go along with that, because maybe if it was called British, it would be more popular, and maybe we'd even get some extra rights that are missing from the European Convention on Human Rights. You know, the kind of rights that we tried to introduce in the first place at Liberty when we called our Bill of Rights a People's Charter, of course, using the language of the Chartists. But we then got an inkling into what was proposed when Chris Grayling, who was then Shadow Justice Secretary, came out with his discussion paper on what a British Bill of Rights would look like. And there were, as some of us predicted, no new rights in this British Bill of Rights, but there was 3 very interesting things that were in this discussion paper, which was the model of what a British Bill of Rights would look like. First of all, the British Bill of Rights will be limited to the most serious cases. Now, this means all the people who, since those early cases that the New Labour so reacted against, which were bound to be the early cases, by the way, the early cases were bound to involve crime and terrorism, because those were the hard issues where there was a lacuna in our law in a very testing time. And it was obvious, I mean, Matthew, you're a barrister, it was obvious that smart lawyers would use the Human Rights Act to try to defend their clients, which is what everybody has a right to, a defense under our common law. So it was inevitable the first cases would be very tough ones like that. But as the years went on, disabled people, elderly people, people with learning difficulties, people who were detained under the Mental Health Act, more and more of them have benefited under the Human Rights Act, both out of the courts and inside the court. And of course, this is what David Cameron actually alighted on. Do you remember the phrases, you know, those human rights and health and safety legislation that he was so opposed to? They were talked about in the same sentence, because it was all a sense of, you know, nanny state interfering. And a lot of the left criticism of bills of rights wafted away on this, because they realized that the objections were actually to regulation and to the empowering of ordinary people to confront officials, whether they ever got to the courts or not. A couple who'd been separated in an old people's home and sent to do different care homes could then find that they could be put together. A mother whose baby was taken away from her randomly in a prison, a tiny baby, could then make the case, no, I can keep my baby with me. My baby needs to be with me in their early days. This kind of change came about only through the Human Rights Act, and was the very sort of measures which were beginning to make it popular were in their sights. So their objective was not to make the Human Rights Act more popular by calling it British, but to explicitly eliminate what they saw as this reinterpretation of the European Convention, which was fine in its Churchillian earlier days, but was now being used to create a nanny state. So on the one hand, they were going for what they described as non-serious cases. On the other hand, when there were what they call serious cases, such as torture being exported overseas, they wanted to define more precisely what we mean by torture. So it became clear that this British Bill of Rights was a British non-Bill of Rights, only for British people. And the problem with that is that there was no other way they could go, because if the whole point was to end the headlines which they'd helped elicit against all these bad people and all these undeserving people using the Human Rights Act to gain rights they shouldn't have, if the aim was to end that rhetoric, they couldn't possibly introduce a British Bill of Rights that basically gave the same rights to most people, because that would then be known as the Tory Bill of Rights instead of the Labour Bill of Rights. So inevitably, of course, what they were proposing would be more restrictive. I think Johnson has got wise and realised it's a hiding to nowhere. So far better to kill off the Human Rights Act with 1,000 cuts, and we've seen it already with the Overseas Operation Bill, which is basically encouraging derogation, you know, which means standing outside the Human Rights Act, formally outside the European Convention on Human Rights, formally whenever they can, and to basically prohibit the use of the Human Rights Act when it applies to acts overseas. So it's the first narrowing of the scope of the Human Rights Act. And we've got a commission that's going to be formed, we're told, and we've been also told that the next aim is deportation cases, the use of the Human Rights Act to prevent deportations, possibly even to prevent asylum cases being lodged in the first place by some of the most vulnerable people in our society. So very much now trying to make this distinction between British people's access to rights and non-British people. We need to watch this space. This very week, Gordon Brown, you raised Gordon Brown, Matthew. He referred to his attempt, which I think genuinely was an attempt, to make the Human Rights Act, if you like, more popular by adding to it with economic, social and cultural rights. And I was brought into some of that work quite explicitly, but it didn't go anywhere in the short time that he was Prime Minister. Keir Starmer was also brought into that work, as was Lord Leicester. But now, if this government were actually going to try to repeal the Human Rights Act rather than kill it with 1,000 cuts, I think they'd find it more difficult than they would have, because it has now led to outcomes such as the Hillsborough inquiry, the prosecution of John Warboys, the black cab multiple rapist, the overturning, as I said, of the bedroom tax for disabled people. It is now starting to become meaningful to more and more people in their everyday lives. So should the government to seek to repeal the Human Rights Act now or withdraw from the European Convention on Human Rights, I believe they will have a fight on their hands, but we should be warned. They will always use warm words that don't sound like what they're actually intending to do, like amend the Human Rights Act, like a British Bill of Rights. They will always use that approach. And isn't that why, as children, we were taught nursery rhymes? We were taught children's stories, like Red Riding Hood. The wolf came looking like Granny. He didn't come like a beast with big sharp teeth. That's what we have to remember, and we have to be sharp. And that is why I commend the work of the Labour campaign for human rights, to keep the flame going, to understand what we have to lose. Mostly people who are most vulnerable, who have nowhere else to turn, have to lose if we lose the Human Rights Act in just 20 years, after so many decades of campaigning. If we lose it now, we will have lost something that was one of the proudest measures, I think, of any Labour government. Thanks.
Thank you so much, Francesca. That was a wonderful note to end on. We've well exceeded an hour, so thank you for being so generous with your time. And it really struck me as you were sort of concluding the sort of to the present day situation of human rights, how hopeful I think I am, particularly, regarding Keir Starmer's history, Sir Keir Starmer's history as a human rights lawyer, how I really hope that the Labour Party will continue to make the case for the Human Rights Act and be proud of the history that it has in implementing it, rather than, as I personally, I said I feel slightly uncomfortable with how it was kind of almost excused, and then obviously after 9/11, and we saw it and we discussed it, kind of underplayed consistently. And I hope that the Labour campaign for human rights will continue to make the positive case for the Human Rights Act, as like you said, it's a piece of legislation that we should be really proud of, and continue to make the case for, particularly as the current government is reviewing various things and continuing to undermine it. I don't know if you have any points there.
Yeah, no, completely agree. Lovely note to end on, Francesca. We, as a campaign group, will absolutely be fighting for the Human Rights Act. It's one of the campaigns we've just started as a new campaign. And not just that, actually. We're not only calling to protect the Human Rights Act, we want more rights. And we're going to continue our campaign for economic, social and cultural rights as the new chapter of human rights, domestic human rights in the UK. There's cause for hope for all of those things, I think.
I think so. Thank you so much. It's been a real pleasure to hear from you, and I've learned so much from you. Thank you.
Been a real pleasure for me too. Take care.
Thanks.
Bye.
Bye.
Bye.